Welcome back to the Deep Dive. Today we're diving into a fascinating piece of legislation that, at first glance, might seem a bit dry, a bit bureaucratic, but trust me, the Fundraising Act 107 of 1978 offers some incredible insights into how society grapples with generosity, how it builds public trust, and, importantly, safeguards against exploitation. Our mission today is really to unpack this consolidated act, make it clear, make it engaging, whether you're just, curious about charitable giving or maybe you're a law student looking for some practical application. We'll look at its core purpose, the key provisions, the legal landscape it reshaped, its real-world impact, and why its principles still matter so much today.
Exactly. And it's more than just, a dusty old legal document. It's really a foundational blueprint. It helps us understand the whole legal side of charity and relief efforts, helps us grasp not just what it says, but why those rules are so crucial for public confidence, for effective giving.
Right. And we've got the Consolidated Act itself right here. It was signed into law June 20, 1978, and officially kicked off September 1979. And it's been updated over the years, right up until September 1998, with a review as recent as March 2025. So it's definitely a living document. It's evolved.
It has indeed.
Okay, let's peel back the layers then.
Yep.
So before we get into the nitty-gritty, what was the big picture here? What was the problem this 1978 Act was actually trying to solve?
Well, at its core, the Act aimed to provide for control of the collection of contributions from the public. Simple as that, really. Think of it as trying to bring some order, some accountability to an area that maybe felt a bit like the Wild West before. It's about making sure that when you, the public, donate your hard-earned money or, valuable goods, those contributions actually get to where they're supposed to go instead of just disappearing or being misused somewhere along the line.
Okay, so bringing order. How did it do that?
It set up some key structures. It created the role of a director of fundraising, someone specifically tasked with overseeing these collections. And it also established several national funds, like the Disaster Relief Fund, a South African Defense Force Fund, a Refugee Relief Fund. Plus, it laid down rules for declaring major events as formal disasters, which helps mobilize national support. It was quite a comprehensive effort, really, to systematize public giving.
So it wasn't starting completely from scratch. It mentions repealing older laws. What was the situation before this act?
That's right. It effectively replaced parts of the National Welfare Act of 1965 and its amendments. Now, some regulations did exist back then, but they were often a bit fragmented, maybe tied specifically just to welfare organizations. This 1978 Act was a deliberate move. Consolidate, clarify, strengthen the entire regulatory framework for all public fundraising. It created a much more unified, robust system for oversight, protecting the public, really, moving from a sort of piecemeal approach to a cohesive national strategy.
And something that strikes me as quite smart, looking back, is the really broad definition of contributions. It's not just cash, is it?
No, not at all. It includes movable or immovable property, including money or anything that can be exchanged for or converted into money.
Wow.
And collect also covers everything, soliciting, accepting, obtaining, the whole process. Why do you think they cast such a wide net?
Well, it feels like it stops people finding loopholes, right? Like saying, oh, we're not collecting money, just goods.
Exactly. It anticipates that kind of ingenuity, people trying to maybe sidestep the rules. By including property, things exchangeable for money, it ensures oversight over all forms of public generosity, a donated car, a painting, even clothes. If it's collected publicly for a public benefit, it falls under the same scrutiny as cash. It's a critical barrier against potential exploitation. Makes it much harder to hide behind technicalities.
Makes perfect sense.
Okay.
Okay, so with that wide scope set, how does Chapter I actually start building the regulatory structure? What's the absolute first rule?
Well, the foundational principle is laid out crystal clear, Section 2. It says, no person shall collect contributions unless he is authorized thereto in terms of this act, and unless the collection takes place in accordance with the provisions of this act.
Right, so straight off the bat, no authorization, no collection, it's illegal.
Precisely. It sets up that essential gatekeeping function. Only legitimate efforts with proper oversight get the green light to ask the public for support.
And who holds the keys? Who gives out this authorization? You can't just, start a charity website and put up a donate button.
No, you can't. That's where the director of fundraising comes in, appointed by the minister. The director basically holds the keys to public fundraising. They grant written authority, they specify the exact purposes, the geographical areas, they handle registering branches, and significantly, they can also grant temporary authority, for urgent things, short-term needs.
Ah, okay, like for a sudden crisis.
Exactly. Those temporary permissions are usually up to 90 days, maybe extendable once. It shows a kind of practical understanding that crises happen fast and need a swift but still controlled response.
Now, here's an area I think could really damage public trust if it wasn't handled carefully. Section 7 talks about collecting contributions for remuneration, getting paid to fundraise. What does that mean for donors? Why is that distinction so important?
Oh, this is a huge provision for transparency, a real game changer back then. If someone's getting paid for their fundraising efforts, maybe a professional fundraiser, they need special written permission from the organization, and a copy of that payment agreement must go to the director.
Oh.
But the crucial part for you, the donor, is this. The collector has to tell the public they're collecting for remuneration, and if you ask, they have to give you the details of their agreement. Any ads also have to state it clearly.
Wow, that's transparency forced, essentially.
Absolutely. Before this, donors might have given money without realizing, a big chunk was going into the fundraiser's pocket. That erodes trust fast. This empowers donors, gives you the information to make a truly informed choice about where your generosity goes.
That's a massive protection. Knowing how much actually gets to the cause is vital. But what if an organization disagrees with the director? Maybe their authority gets pulled. Can they fight it?
Yes, definitely. The Act includes a pretty solid appeal process. If an organization doesn't meet the conditions or maybe gives false info, the director can amend or even withdraw their authority. But the organization isn't just left hanging. They can appeal to an appeal committee.
And who's on that committee? Is it independent?
It's designed to be. It's chaired by a magistrate with at least 10 years experience, plus 2 other people who know fundraising but have absolutely no direct interest in the organization that's appealing. So it ensures a degree of fairness, balancing that regulatory control with due process.
Okay, so contributions are collected legally with authorization. Can the organization then just spend it on, say, a new office building if they feel like it?
Absolutely not. Section 11 is very clear. Contributions may be used for authorized objects only.
Authorized objects, meaning what they said they'd use it for initially.
Exactly. You can't just change your mission halfway through without getting explicit written consent from the director. It's a key safeguard against, mission drift or outright misuse of funds.
And how do they prove they're sticking to the plan?
Well, Section 12 mandates meticulous accounting. Organizations have to keep detailed records, submit regular reports, financial statements, and crucially, these have to be audited by a registered accountant.
Okay, audited financials. That sounds standard.
Yes, but here's the kicker for public accountability. Those audited financial statements must be available for public inspection. Anyone can ask to see them.
Really? That level of transparency is quite something, designed to build that public trust you mentioned. So the Act ensures individual organizations are transparent. But what about mobilizing resources for, huge national crises, widespread emergencies, or specific big societal needs? That's where those specialized national funds come in, right?
Exactly right. Chapter 2 really broadens the Act's scope beyond just regulating private fundraising. It establishes these dedicated national funds. Initially, there were 3: the Disaster Relief Fund, the South African Defense Force Fund, and the Refugee Relief Fund. But then, as society's needs changed, 2 more were added later on: the State President's Fund in '83 and the Social Relief Fund in '91. These allow for a much more centralized, coordinated response to really significant national issues.
And each one has a very specific job, doesn't it? Can you quickly walk us through what each fund aims to do?
Sure. Section 18 lays it out clearly. Each board has a distinct, vital purpose. The Disaster Relief Fund, that's for helping people, organizations, bodies suffering damage or loss from major events. Think floods, droughts, big accidents. It's about national resilience.
Makes sense.
Then the South African Defense Force Fund. That's specifically for helping current and former SANDF members and their families who face financial hardship because of their service, a commitment to those who served.
Okay.
The Refugee Relief Fund provides assistance to refugees, obviously, addressing the needs of displaced people within the country. The State President's Fund, added in '83, remember, was specifically set up to help victims of terrorism. Medical costs, rehab, financial hardship caused by acts of terror. It reflected a very specific concern at that time.
A sign of the times, perhaps.
Indeed. And finally, the Social Relief Fund. Added later, it deals with psychosocial problems from violence and provides general social relief to victims of violence, again addressing emerging needs for community support.
It's clear these aren't just passive pots of money. They're actively managed by boards. How are these boards set up?
Right. Each fund has its own board, appointed by the minister. And importantly, these boards function as a juristic person.
Meaning, like a company.
Sort of. It means they're treated as a legal entity, separate from the individuals on the board. They can own property, sign contracts. It gives them stability and continuity. And these boards can collect contributions themselves, or they can authorize other people or organizations to collect specifically for their fund's purpose. It allows for targeted expertise, and efficient response.
And where did the money come from initially? Did they have to start fundraising from scratch?
Section 22 shows some smart strategic thinking there. Instead of starting from zero, several existing funds were actually merged into these new structures when the act began.
Consolidating resources.
Exactly. Things like the old National Relief Fund, the Fund for External Relief, the National Mine Disaster Fund, the Central Flood Disaster Fund from '74. They all had their assets transferred into the new Disaster Relief Fund. Same happened with existing refugee and defense force funds. It was a clever way to centralize things, formalize disaster and relief funding, avoid duplication, and create a stronger national response right away.
That is practical.
Yeah.
And speaking of disasters, who actually gets to decide what officially counts as a disaster to trigger that specific fund?
That's a high-level decision. Section 26 states that the state president makes that call.
The president.
Yes, by proclamation in the government gazette. It has to be an event causing serious material damage or loss or distress, and where public support for relief is clearly needed and likely. So it formalizes the process, making sure only significant, nationally recognized crises trigger that specific fund. It differentiates major national emergencies from more localized problems.
Okay, so we've got the general rules, the specific funds. What else is in there to make sure it all works? The enforcement side of things.
Right. Chapter 3 covers those important general and supplementary bits. For example, Section 28 says all these authorized organizations and their branches need a written constitution that meets certain conditions. And any changes to that constitution need approval from the director or the relevant board. Basic good governance, really.
Makes sense. Now, there's a provision here that gives the state quite a bit of power. Section 29. The minister may prohibit collection of contributions. That sounds very broad.
It is a significant power, designed for pretty immediate intervention if needed. If the minister thinks it's in the public interest, they can, just by putting a notice in the Gazette, stop the collection of contributions for any purpose, in any way, by any person or organization.
Wow, any purpose.
Yeah.
Without notice.
Yes, the Act specifically says it can happen without giving any person or organization notice or an opportunity to make representations.
That's strong stuff.
It is. It's a powerful tool for situations where maybe public trust is severely at risk or national interests are seen to be paramount. It really underscores the emphasis on protecting the public and the integrity of giving.
Okay, so how are these rules actually enforced on the ground? What happens if someone's suspected of, dodgy dealings?
That's where Section 30 comes in inspection of affairs. It's crucial. The director, if the minister agrees, can appoint inspectors. And these inspectors have some pretty robust powers to investigate any organization or person they suspect is collecting contributions unlawfully.
Like what kind of powers?
Well, they can enter premises without prior notice, without a warrant.
Just walk in.
Pretty much. They can search for, demand, look at, remove, even seize money, financial records, documents. They can demand explanations for entries in the books. They can interrogate people under oath members, employees, auditors, representatives.
Serious stuff.
Very. But importantly, anyone being interrogated has the right to have their legal representative present. So there's a balance there between the state's power and individual rights.
Still, it sounds like if you were running an unauthorized collection, these inspectors have real teeth. They're not just sending a polite letter.
Definitely not. It's a strong deterrent.
And what if they find contributions that were collected unlawfully? Do the collectors just keep it?
No. Section 31 deals with that disposal of unlawfully collected contributions. The director can order the people involved to provide information, hold on to the funds, transfer them to the director, or even return the contributions directly to the donors if they're known. If returning isn't practical, the minister steps in to decide how those funds should be used. So it ensures unlawfully collected money doesn't just get kept by the collector. It's another layer of public protection, preventing illicit gain.
Okay, with all these strict rules and powerful enforcement, does this act apply to absolutely every collection? Like a school bake sale, a church collection plate?
That's a great question. And no, it doesn't cover everything. Section 33 lists several really important exemptions from those main Chapter 1 rules. It helps understand the Act's practical limits.
So it wasn't meant to regulate every single time money changes hands for a good cause.
Exactly. It carves out specific spaces. For instance, contributions collected under other specific laws are exempt, avoids doubling up on regulations. Money collected by or for the state itself, local authorities, hospital boards, that's out. Collections from members of an organization just because their members think club dues, that sort of thing.
Right.
Collections by religious bodies during services or for their religious work if they have written authority. That's a specific allowance. Educational institutions collecting from former students, parents, guardians. Collections by or for political parties, that's separate. Money raised under university or college supervision for development. And finally, collections by specific organizations the minister might designate.
So it's quite deliberately calibrated then. It focuses the main regulatory effort where public trust is maybe most vulnerable in general public appeals.
Precisely. It maintains that crucial oversight, but allows other established specific forms of fundraising to operate outside that main authorization framework.
And if someone does break the rules, what are the actual consequences? Does the act have legal bite?
Oh, yes, absolutely. Section 34 lays out the offenses and penalties quite clearly. If you contravene the really fundamental rules like collecting without authorization or misusing the funds you collected, you could face a fine up to R$1,500 or imprisonment up to 3 years or even both.
Okay, that's serious.
It is. And even for lesser offenses, like maybe not complying with requests from the director or obstructing an inspector, there are still penalties, fines up to R$500 or 6 months imprisonment or both. It definitely shows the act has legal weight and is serious about enforcing proper conduct and accountability.
So we've really taken a deep dive into this Fundraising Act of 1978. We've seen how it meticulously defines fundraising, how it authorizes it, regulates it, from those general rules right through to the specific national funds for disasters, defense, refugees, social welfare. And we've looked at those serious enforcement powers, the inspectors, but also those vital exemptions for specific types of collections. It's actually a pretty sophisticated piece of legislation when you unpack it.
It really is. And what's compelling is how this single act reflects such a deliberate, comprehensive effort, trying to balance that public generosity we all value with robust accountability and transparency. It's a powerful testament, really, to the complexities of managing public trust, managing resources, and the enduring need for clear legal frameworks. Frameworks that handle both broad principles and specific societal needs. It gives real-world significance to every clause.
Yeah, this deep dive definitely shows that even decades later, those core principles, transparency, accountability, making sure funds are used properly, they remain profoundly relevant, don't they? It still offers a crucial blueprint for ethical, effective charitable giving. It really shaped the landscape of how we support each other.
And that brings up a really interesting question, maybe for you listening to think about. In today's world with instant digital fundraising, global crowdfunding platforms, decentralized online appeals happening all the time, how do these foundational principles from a 1978 act, how do they translate? How do they adapt to the challenges and the opportunities of our interconnected world now? What do you think?
That's a great question to ponder. Keep those insights coming. And we'll be back next time for another deep dive.